Well, thank you very much for inviting me to come here. I'm very happy to speak after Alberto and Juan, because I think they really set the stage. And now you're going to have to listen to a lawyer, which is much more boring. And I'll get into some detail. But I think it's really important to keep in mind the presentations we heard earlier, because we shouldn't get lost in the details, in the legal details. I think we should be aware of some of the issues and some of the legal implications, but not lose sight of the main issues. And the real issues, I think, were already really spoken about this morning. So one thing, what use are these treaties actually? And we've seen that economically, at least from a developing country perspective, they might not make any sense. At least there is absolutely no evidence that you need these treaties to attract investment. So that is definitely one thing. The economic reasoning behind the treaties, what are they really for? I think we've heard this morning that it's heavily overestimated and probably just a myth. The second thing is the asymmetry. I think that was a really important point as well. The asymmetry in rights and obligations, always to keep that in mind, and to see the investment treaties as a part of this overall framework that really tilts the balance in favor of private actors. And private actors, I mean, of course, not affected communities, but the economic actors. So let me just start a little bit and give you a bit of background. I'll go very quickly because we've pretty much covered these issues, and many of you have been involved in all of these initiatives. As you all know, there is no international or multilateral framework on investment. But at the same time, we say that on investment protection would be more correct. We, of course, already have many elements of investment liberalization, especially liberalization, in many of the multilateral treaties, especially at the WTO. And we've had initiatives to go further than that, to go beyond liberalization of services, for example, of the trade-related investment measures, to go beyond that when the OECD initiated the multilateral agreement on investment. And I think there are people in the room that were involved in this initiative to get to counter it and to say, this is going down the wrong road. And that was 1997. We'll see a little later, in 1997, we had no idea what was going to happen. In fact, we hardly had any cases in 1997. But already then, at least people in the room recognized that there's something wrong with this. We don't know the details yet, but this cannot be right. And many developing countries also opposed the MAI. Then it came up again with the WTO Singapore issues. Again, developing countries in Cancun strongly, and also civil society, backed by civil society, opposed a multilateral initiative on investment in Cancun. Now, be aware, OECD, and even UNCTAD to some extent, still have this on their radar in different ways. And I think it's very important to follow what the two organizations are doing in this area to move towards a multilateralization of investment treaty or investment protection. So we were quite successful in blocking some of the multilateral initiatives. We were, unfortunately, not at all successful in stopping the development. In fact, we now have 3,000 investment treaties, bilateral or chapters in free trade agreements. 3,000. That's enormous. And we also have expansions that are surpassing everything we might have imagined. It's true that originally, and the big chunk of investment treaties still is between developed and developing states. And there's definitely, as we heard this morning, an imbalance of power in many of these treaties. But there are some dormant, or they're not dormant anymore, there are some treaties that are also becoming very important, such as the Energy Charter Treaty, where we have most European states involved. And we'll be discussing later in these days the case brought by a Swedish multinational company, actually a state-owned enterprise, which is quite interesting, suing the German government. The second time for its investment in the nuclear sector. So, in a way, this is becoming something gigantic, and it's becoming it's touching the relationships between all kinds of actors and players and states. Also, blocs are beginning to negotiate. So, on the one hand, you have the regions. So you have NAFTA was one of the first, but then you also have in Africa and in Asia, you have regional blocs negotiating investment protection, giving rights to foreign investors within those regions, and sometimes beyond. And in addition, those blocs, as regions, are negotiating treaties. What we're aware of is EU will start negotiating, or is already negotiating, as a bloc. So that means that if the EU negotiates with India, obviously all European member states and all their investors can sue India. It's not just one. It's not just Germany. So the question really is, why did this happen? And the question was raised from the public. How is this possible? It's really hard to know. I mean, it really started to protect Western capital from the impacts of decolonization, but for 30 years we didn't know that these instruments could actually be used. They weren't used. And now, developing countries, we work with several developing countries per year. We're finding that often they really still don't know the impacts of, or the legal impacts of these treaties. But also, it's very much that especially the developed world, but the capital exporting countries are really convincing them that they have to be part of the club. They have to be seen as good sports. And in order to do that, you better sign this. And still, ministers are forcing their officials that are beginning to see the problems. The ministers are saying, no, I'm traveling to this country X. We have to sign something, and it will be an investment treaty. It's still a photo opportunity, unfortunately, for many states. So there's a lot of capacity building going on, but a lot is the sentiment, we have to be part of the club. And if we want to be part of the club, we have to sign these instruments. So this is just a little bit of background, but now is maybe the more boring part, which is the actual obligations in these treaties. And I think that many of you already know most of what I will be saying, and some of the aspects were already discussed in the previous sessions. So in these investment protection treaties, we typically have obligations for the host state where the investment is taking place. And typically we have no obligations put on the private actor, the investor. And this is coming back to contributing to this asymmetry that was referred to earlier this morning. Let me also just specify here that this morning we kind of mixed up or discussed both liberalization and protection. in the investment treaties, for example, in Europe, the European states signed, we're talking primarily about post-establishment protection. So we're talking about that the investor gets rights once the investor is in the country and established. Then the investor has rights under the treaty. But increasingly, we see that the investor has access rights as well under the same instruments. And very often this is in the investment chapter of the free trade agreement, but increasingly even in the investment treaties, that it goes beyond post-establishment to pre-establishment rights. So the pre-establishment rights are the ones that are linked to liberalization, to that discussion, while the post-establishment is really about giving the investor this specific special protection. The two guarantees that the investor has that you are surely familiar with, also those from the trade campaign, are the non-discrimination principles. National treatment and most favored nation treatment. These raise a range of issues, maybe similar in a way to those raised in trade, but they also raise additional issues. You know, first of all, the ones that we know from trade is what do you compare? In trade, we say, well, what products do you actually compare? Here, it's what investments do you compare? Can you just compare a factory that's right next to a vital water source compared to another one somewhere in the desert? You know, how do you compare investors, and how do you then say, are they treated the same or are they treated differently? Because that's what non-discrimination is about, right? Because you have to treat similar investors similarly, but what is similar? So those are issues that definitely are important. But in addition, the national treatment is where capital exporting countries seeking market access sneak in their pre-establishment rights, and we'll see that. So national treatment and pre-establishment rights, market access rights, are intrinsically linked. Most favored nation treatment, we already had really interesting discussions this morning. Most favored nation treatment is particularly complex in the investment framework, even more than in trade, where we have a multilateral system, and it's already complicated there. But here, exactly what was spoken about this morning, well, what about, okay, EU and Canada are negotiating. Well, what about the US? What does that mean for the US? US has favored MFN. What can the US investor import from other treaties? And we'll see here there's a lot of debate on MFN in investment law. Fair and equitable treatment, we'll look at a little bit more detail. This is something that might look very harmless, but is extremely important. The investor gets a guarantee of being treated fairly and equitably. And every state would say, of course, that's what we're going to do. But what does it mean? And we'll see that this, for example, is exactly what the Swedish power company Nuclear, for its nuclear investment in Germany, is putting to the forefront, saying, this is unfair. We were not expecting for you to get out of nuclear. So we have rights. It's unfair. We had a legitimate different expectation. Then expropriation, that's also something frequently used. Indirect expropriation, something where actually the title isn't transferred, but you have an effect on the profits of an investment, and the state then also has to compensate. And the free transfer of investment or capital is basically what was discussed this morning, but in contrast to trade, very often there are no exceptions to this free transfer clause, which also Of course, the most important the aspect of an investment treaty that makes it so powerful is the investor state mechanism. If there is one thing a campaign can ask for to be the most powerful, it would be to not have investor state arbitration. And Gus will look at this in a bit more detail. Since I only have 5 minutes, I won't go back to this, but we can actually, on the last day, we can go into a little bit more legal detail of these clauses. National treatment and MFN. Let me just add to MFN, it's quite interesting that investors have imported not only substantive rights of treatment, but also rights relating to dispute settlement from other treaties. So if I'm a Dutch investor bringing a claim under a Dutch treaty, I can rely on another treaty that my partner, the host state, has signed a treaty with. So I can basically look, let's say I invest in Uruguay, then I can look at all the treaties Uruguay has signed and import from those treaties. That's the problem. And Uruguay may have, I don't know how many treaties, 20, 30, 40, I don't know. And so not only can you import substantive rights, but procedural rights. And there are big fights amongst arbitrators today whether this should be possible. And it's very interesting because for the first time in the last year, you have 2 dissenting opinions saying this is unacceptable. But it was the minority and the investors still won because there were always 2 arbitrators that actually said, yes, you're allowed to import these rights. Fair and equitable treatment, as I said, a very, very important clause. I can't go into detail now. Expropriation, also extremely important, used by all investors in all claims, basically. And we're talking about measures having equivalent effect to expropriation or indirect expropriation. And you can look up in this little booklet that we prepared what some of these issues mean. Oh yeah, I forgot the umbrella clause. Maybe I'll spend just 1 minute on that. Umbrella clause sounds very funny. It actually means that maybe about 40%, there was a study a few years ago, 40% of all treaties have a so-called umbrella clause, which means that they have language in the treaty that allows to bring all kinds of obligation the state has under the treaty. If you bring it under the treaty, it means that you can go to arbitration to bring in rights under contracts, to bring in rights and obligations under domestic law. It basically means that you're taking everything to international arbitration that could somehow have obliged the state to do something. And this is a little bit complex, but the important thing is that you're allowed to litigate things in international arbitration that normally you would resolve at the domestic level. And this I won't go into detail because Gus will. The investor-state dispute settlement mechanism, definitely the most important aspect of investment treaties. You can see the increase of arbitration. Very interesting, you'll see that there's a massive increase, late 90s, 2000, and that's with NAFTA. That's when you had this, actually a treaty with 2 developing countries, and they just started suing using this mechanism. After NAFTA, lawyers started really building their sections, new sections on international treaty-based arbitration, and just are telling their clients to sue states, where you see a very concrete increase. And probably there are many more cases because many stay secret. Just as a comparison, I thought it would be good to see in the International Court of Justice in between 2000 and 2010, you had 26 cases, WTO 233, and investment treaty, many more. Of course, this is just the starting point for what maybe Gus will expand on. The arbitration system lacks transparency. There are massive conflicts of interests with the arbitrators, and the decisions are very strong and enforceable, final, which means that you're giving tremendous power to three people that are actually conflicted to decide on national policies, and in a final way, and in a way that can be enforced. Here, again, the lack of balance, we already heard all that, but just on a note, where if people start thinking and campaigning about these things, there are many countries that are seriously already questioning the system. It's not like we're asking for or reconsidering issues that are, let's say, crazy. Countries are recognizing that this system is out of control. And we have countries that never signed anything. We have countries that are making big changes, such Ecuador and Bolivia. We see countries like South Africa evaluating. At the EU, a lot could be going on. We don't know where it's heading yet. And we have regional systems that are trying to put together a more balanced system. So there is a lot going on, and I can't go into detail, but just to say this is a system that can be changed, that can be fixed, and that maybe there is some kind of exit strategy as well. Thank you.